Hello everyone, welcome to LUKMAAN IAS. Today we are going to have the Hindu analysis of 17th May 2021. Let us see which are the important articles in today's The Hindu newspaper. Yes, these are the important articles from today's The Hindu newspaper. For mains purpose and for prelims purpose we have segregated them. Let us take overview of all these articles first. The restructuring the tribunal system. So the context of this particular article on page number 7 op-ed page is the Tribunal Reforms Ordinance 2021 that was recently promulgated by President. So the context of this article is that particular ordinance which has abolished many such appellate tribunals and transferred their jurisdiction to other existing judicial bodies like high courts. So yes, which are these appellate tribunals that have been abolished, and then we will look into some criticism regarding this particular ordinance and its provision, and ultimately the need for National Tribunals Commission that is needed here. So yes, we will talk about the way forward also. This is important from polity perspective, GS2 paper, and very important especially those who are having public administration optional subject, right. Yes, next it is getting from bad to worse for women workers. So from social justice GS2 paper, essay paper, along with that GS1 society part, the impact of pandemic lockdown on women workers in India. There can be specific question or specific essay topics regarding impact of pandemic on women. So you need to focus on working women also, and here the article is providing very good facts, data. You can support that in your providing your arguments in mains examination, as well as some way forward also. Yes, from that aspect we are going to take input. Then using all options, the context of the article, it is talking about the recent constraints, supply constraints for the vaccines for the domestic demand that we are facing, and that is why vaccination policy or vaccination drive has taken some setback. So that is why the the article is saying that the patent rights or the compulsory licensing of these vaccines should be provided to other vaccine manufacturers in the country. Okay. So from that aspect we have to take input here, and for specifically prelims examination we have to understand the provisions in the Indian Constitution regarding tribunals. What are these administrative tribunals and other tribunals under article 323A and 323B. So that is important for prelims examination. In the end, COVID-19 related developments on the daily basis we are having the follow up on that, and lastly some prelims MCQs, multiple choice questions for our prelims examination from today's The Hindu newspaper. Okay. Yes, let us go into details of all these articles first. Yes, first article, restructuring the tribunal system. Now the context of the article is this particular Tribunal Reforms Ordinance 2021 recently promulgated by the President. This particular ordinance is seeking to abolish the various appellate tribunals under different acts enacted by the Parliament, and transferring the jurisdiction of these appellate bodies, tribunals, to different existing judicial bodies like high courts and other civil courts. Which are these appellate bodies? For example, the Cinematograph Act 1952, under this appellate tribunal was there. Now this is going to be abolished and the jurisdiction is transferred to the respective high courts, right. Then again the Patent Act 1970, Copyrights Act, Trademarks Act, GI Tag Act, right. So all these acts basically they are focusing on the patents system in the country, Customs Act. So whatever the appellate body that we had for under this particular acts for the, let us say, redressal of the grievances, disputes, these appellate bodies were established. Now they are being abolished and their jurisdiction is transferred to the existing bodies like this. Now what are the problems with this ordinance or such kind of, let us say, reforms? We have to understand the criticism also. Yes, what happens is in Indian Constitution there are two types of tribunals that are to be established under Article 323A and Article 323B. Under this, only administrative tribunals are established, while under Article 323, there are, let's say, different tribunals for adjudication of disputes in different matters, like for example trade or other such matters. Whenever there is a dispute resolution required, so tribunals are established under Article 323B. Now these articles were inserted in our constitution through 42nd Constitutional Amendment Act 1976. Okay, they were not originally present. Now this is basic information. Now we have to understand the present reforms being undertaken through this Tribunal Reforms Ordinance 2021. First thing in terms of criticism is that bypassing usual legislative process. Surely the ordinance route that is being taken by the government to bring such reforms is not good. Appropriate legislative process, deliberation and discussion in the parliamentary houses should have been taken, and then we can say that passing of this particular bill by the parliamentary houses and ultimately they can be enacted. This appropriate procedure should have been followed. Bypassing such legislative scrutiny is not good for any democratic country. Next, no stakeholder consultation, especially when we talk about the specific, let's say, acts related to like Cinematography Act is there and the appellate body, appellate tribunal is there. So stakeholders involved in that particular area have not been consulted, and therefore we can say that this is unilateral process to bring the reforms. The third important aspect, despite the Supreme Court's direction in Roger Matthew versus South Indian Bank 2019, no judicial impact assessment was conducted prior to abolishing tribunals through this ordinance. That means Supreme Court had directed the government before abolishing such tribunals, the judicial impact assessment should be done, and then only such tribunals should be abolished. So this is not done. Such kind of specific information you should know to write in the mains examination. And at the same time, some reforms have been done in terms of appointment of chairpersons and members to the tribunals. For example, this 4-year tenure for chairpersons and members of the tribunals have been fixed. This is a disregard to Supreme Court's direction of fixing 5-year term in Madras Bar Association 2020 case. That means this is against the direction of the Supreme Court. So it can be or it may be declared null and void, as we can understand this ordinance is going to test the, what you can say, exam before the Supreme Court soon. In India, executive interference in the functioning of tribunals is often seen in the matters of appointment and removal of tribunal members, its chairpersons. At the same time, in day-to-day working, for example, provision of finances, infrastructure, personnel and other resources required for its functioning. That means the independence, the autonomy required for the effective working of these tribunals is affected because of such interference. This is the problem that our tribunals are facing, and that's why there is need of establishing or constituting National Tribunals Commission. Now this National Tribunal Commission, this idea was first mooted by Supreme Court in L. Chandra Kumar case, judgment 1997, very famous, very important when we talk about the tribunal reforms, L. Chandra Kumar case. So this National Tribunals Commission the idea was given by the Supreme Court. However, this has not been established yet. Such kind of NTC must be established through constitutional amendment or should be backed by the statute of the parliament. Why? Because if it is not provided such kind of guard or protection, then again it is not useful, because there will be again interference of the executive in its working. So, to ensure the independent and autonomous working of tribunals, it should be provided constitutional status or statutory status. Along with that, such establishment of National Tribunal Commission through Constitutional Amendment Act or legal provisions, it paves way for separation of administrative and judicial functions carried out by various tribunals. Along with that, it could set performance standards for efficiency of tribunals and their own administrative processes. So, such unified body at national level, National Tribunals Commission, will ensure uniformity in terms of eligibility criteria for chairpersons and members, their tenure, and the efficiency standards can be established by the National Tribunal Commission. This is long pending reform. This is not been done by the government, while such, let's say, reforms under this tribunal reforms ordinance have been undertaken, which are being criticized. Also, such National Tribunal Commission could function an independent recruitment body to develop and operationalize the procedure for disciplinary proceedings and appointment of tribunal members. So, independent recruitment body, it can act as a such body. Along with that, administrative role of NTC could include providing support services to the tribunal members, litigants and their lawyers. Right. So, such way forward should be mentioned. Always talk about this L. Chandra Kumar case and the directives given by the Supreme Court or the suggestions in terms of tribunal reforms when we talk about this particular topic in GS2 paper polity part, and those who are having public administration optional subject. What kind of question we can expect here? Executive interference in the functioning of tribunals affects principle of separation of powers. With reference to this, discuss the need of constituting National Tribunals Commission. Okay, so at least you should be aware about the provisions of such National Tribunals Commission, as the idea was given by L. Chandra Kumar case in the or by the Supreme Court. Fine. Okay. Now some basics for prelims examination about tribunals. Yes, originally our constitution did not provide for tribunals, establishment of tribunals, but yes, further during from the 42nd Constitutional Amendment Act 1976, it added two important articles in the constitution, or we can say part 14A. So, these articles are Article 323, which provides or empowers Parliament to establish administrative tribunals, and Article 323B, which provides for establishing tribunals for other matters. Which are these other matters? For example, for adjudication of disputes related to matters like taxation, foreign exchange, import and export, industries and labor, and then land reforms, ceiling on urban property, election to parliament and state legislatures. Such kind of, let's say, disputes can be resolved by establishing tribunals under this Article 323B. Fine. So, yes, we have to understand the difference between these two articles also. For example, Article 323A, which provides for establishment of administrative tribunals, such kind of administrative tribunals can be only established through the law of Parliament and not state legislature. So, it provides for central administrative tribunals at a central level, one such tribunal, and at state level, state administrative tribunal, only one such tribunal at each state level. Okay. So, such kind of act, Administrative Tribunals Act in 1985 was let's say enacted by the Parliament, and CAT, Central Administrative Tribunal, was set up in 1985. This administrative tribunal basically deals with the disputes related to recruitment and conditions of service for persons of appointment to the public services of center, state, local bodies, public corporation, public authorities. Fine. So, this is regarding disputes related to public services. Okay. So, you can relate this to this part 14, which is relating to Article 308 to 323 UPSC, All India Services, Central Services, State Services part. So to some extent you can relate to that part, Article 323A, okay, 42nd Constitutional Amendment Act. At the same time, Supreme Court in L. Chandrakumar case 1997, it declared that those provisions of these two articles which excluded jurisdiction of High Courts and Supreme Court as unconstitutional. Hence, judicial remedies are now available against the orders of these tribunals. That means the provisions in this article which had mentioned about no judicial remedy available against these awards of tribunal. However, this was declared unconstitutional in L. Chandrakumar case 1997, and then at present we can understand judicial remedy. That means yes, one can go to High Court and Supreme Court to seek remedy against the orders of these tribunals. Okay. Yes. So this is basic information for prelims examination regarding tribunals. Yes. Next, it is getting from bad to worse for women workers. So the context of the article is that impact of COVID-19 pandemic and the lockdowns on working women. There is a disproportionate kind of impact on the working women as compared to working men. Some important facts, for example, even prior to 2020, only 18% of working age population were employed as compared to 75% of men. This is very important, and this is further going to decline due to impact of COVID-19. Data from Center for Monitoring Indian Economy Private Limited shows that 61% of male workers were unaffected during lockdown, while only 19% women experienced this kind of security. Okay, so by the end of year 2020, 47% of employed women who had lost job during lockdown last year had not returned to work. Around 50% of women, we can say. The equivalent number for men is only 7%. Okay, this is how we have to understand the impact of this COVID-19 pandemic and lockdown. Yes, disproportionate impact. Why we are saying that? Because women were more likely to enter as daily wage workers, while men found avenues for self-employment. And we can understand that on an average, daily wage worker receives less remuneration as compared to self-employed person. That's why the impact is disproportionate. Then women tended to lose work disproportionately irrespective of industry in which they were employed, be it education sector, health sector or other economic sectors also. Women are facing more disproportionate impact. Then with schools closed and almost everyone at their homes, household responsibilities increased for women. This is again disproportionate impact of this lockdown, that women are going to get a burden of this household responsibilities as the husband and the children are staying at home. And looking at the patriarchal nature of society that we have in India, men are less likely to work for this household chores. So that's why the disproportionate burden on working women regarding this household chores, new responsibilities. Right. So what should be the way forward? Yes, expansion of MG Narega in rural areas and introduction of urban employment guarantee scheme targeted to women. Prioritizing opening of schools and Anganwadi centers and engagement with self-help groups for production of personal protective equipment kits, PPE kits. Now this is innovative idea. You can write this. Self-help groups is a syllabus topic in GS2 paper regarding governance and social justice. Then COVID-19 hardship allowance of at least rupees 5,000 per month for next 6 months should be announced for 2.5 million accredited social healthcare activists, ASHA, and Anganwadi workers, most of whom are women. Now this is very important. At present, even at PHC level, primary healthcare level, and at in the rural areas, during this second wave of pandemic, which has reached in the rural areas. Asha workers are let's say doing a very important work in spreading the information about COVID-19 disease, providing some basic services to pregnant and lactating women when there is healthcare access is restricted because of this COVID-19 pandemic to these vulnerable groups. So they are actually the what you can say COVID-19 warriors, and they should be provided such kind of 5,000 rupees per month as hardship allowance. Yes, you can write such way forward in essay paper, GS2 paper social justice, and GS1 paper society also. Right. So we are surely expecting such essay topic, or in GS1 paper society part, or social justice GS2 paper. Next, using all options. The context of the article is the supply constraints that we are facing in the country that is required to meet the demand of vaccination drive that we are having at national stage, right. So supply constraints are one of the reasons why pace of vaccination has fallen in the country. States like Maharashtra, Karnataka, they have stopped the vaccination of 18 plus age group up to 44, right, because of lack of vaccines availability. Along with that, India has rightly sought the temporary waiver of provisions in TRIPS agreement. However, the government has done nothing to bring vaccines and medicines under statutory regime in India to allow for wider availability and diversity of options. This is also important, that Domestic Patent Act 1970 that we have at national stage, that should be let's say invoked for compulsory licensing. For example, section 100 of Patents Act 1970 allows center to license specific companies to manufacture vaccines. Section 92 of the Patents Act allows center to issue compulsory license in circumstances of national and extreme emergency. We can understand that this is public health emergency, COVID-19 pandemic. So such sections of this Patent Act can be invoked, and further manufacturing facilities of vaccines and these drugs can be ramped up. So as a way forward, surely ICMR can license other public sector vaccine manufacturers to help augment its supply of Covaxin. As we can understand, ICMR along with National Institute of Virology, Pune, this had collaborated with the Bharat Biotech to develop this Covaxin. So ICMR is free to license other public sector. At present, two central public sector undertakings like Indian Immunologicals Limited and BIBCOL have already entered into technology transfer agreement with Bharat Biotech. Besides Hopkins Biopharmaceutical Corporation based in Mumbai, other such manufacturers can also repurpose their plants for the production of these vaccines. So the government should not only focus on the international waiver, patent waiver, they should focus also on domestic laws, and whatever the pharmaceutical production capacity that we have, that should go towards this vaccine manufacturing and the life-saving drugs that are to be manufactured for COVID-19 pandemic disease, right. So this is how the context that we have to understand using all options. Yes. Next, COVID-19 related developments at national stage. Yes, Dr. Soumya Swaminathan, WHO chief scientist, says efforts put in next 6 to 18 months will be most critical in battling the pandemic. Okay, the number of new COVID cases in India has shown consistent dip in the past week. At the same time, also drop in test positivity rate. What is this test positivity rate? Number of positive cases identified per 100 tests. This is important for prelims examination. Now this has also dropped. From this graph, you can understand the situation that we have in the country since 1st April, how the cases and this test positivity rate also increased, and now it is declining. Okay, average daily TPR, this blue line is declining, Then the red, average daily tests, yes, they are being conducted at high stage. However, the average daily cases, you can see the black one, that is declining. Okay, so this is a good development. Now, cyclone Taute, okay, this cyclone Taute, yes, this is very important, and the development that is happening in the Arabian Sea, that we are observing since last 2 days. The high speed winds, heavy rain and high tidal waves swept coastal belt of Karnataka, Kerala and Goa as cyclone Taute moved northwards towards Gujarat on 16th May. This is the follow up to this cyclone. On Sunday's newspaper, we have discussed in the Hindu analysis everything regarding this tropical cyclone in Bay of Bengal that we are observing today, and in general basics about tropical cyclone for prelims as well as mains examination. Fine? Okay. Now, yes, these are the practice prelims MCQs that we have provided. You can download this particular PDF of this PPT in the description of this video on YouTube. At the same time, you can visit our website and subscribe to our channel LUKMAAN IAS to receive all these developments, all these documents on the daily basis. At the same time, when you join our Telegram channel, which is there in the description of this video, in that Telegram channel on daily basis we are providing this The Hindu analysis video, this PDF, as well as on the daily basis current affairs, along with that the other important information and practice MCQs also, and the we can say that the explanation of these MCQs is also provided in those Telegram channels. So try to solve these MCQs. You also provide your answers in the comment box of this video, and in this manner in the next day when we will discuss this, you will get to know more about this, how to solve these MCQs also. Okay, this is the second MCQ. Fine. Okay, so these were important developments from today's The Hindu newspaper. As you have got the around 4 months for preparation of prelims examination, it is advised that those already given the attempt, they can spare some time of 1 or 2 months for your mains examination preparation. For that purpose, we at LUKMAAN IAS have started the test series for general studies, essay paper and public administration optional subject. So surely you can have very good practice of writing these answers, get evaluated by expert faculties, and one-to-one interview, or we can say doubt solving sessions with the evaluators and the faculty. For further information regarding this test series, you can contact LUKMAAN IAS. Thank you.